Appellate Attorney David Cole of Dallas. Thank you so much, as always. We appreciate it.
Thank you.
So here we have the Supreme Court's ruling on it. They had talked about the birthright
Mhm.
citizenship case. It's 120 pages, but it really doesn't deal with the legality of the president's executive order trying to end birthright citizenship. But it does talk about the efforts in court to stop it. So, well, what can you tell us about this? It's a little light reading for anybody who wants.
Right. Yeah. No, there's a lot in there, but they say it about as clearly as the Supreme Court ever says anything when they say we're not talking about the merits of the birthright citizenship order. Period. Full stop. The question that was appealed to the Supreme Court was when a federal court says this law is no good, this law is unconstitutional, can it make an order that applies to the whole federal government, a so-called nationwide injunction, or is it limited to the people in front of it and their dispute with the government? And the Supreme Court said here, look, if you go back to when the Constitution became effective and you look at what courts could do back then and think about what the framers had to have been thinking about, there was no such thing as a nationwide injunction. It just didn't exist. Modern invention. And so we're going to go back. We want to always try to follow the original model. We're going to apply that here and hold that the court can't have an injunction that goes to the whole U.S. government. It's forced to speak only, limited to speaking only about the people in front of it who brought the case. Now, on its face, that has nothing to do with the birthright citizenship law. In fact, the court says so. But obviously, it has practical consequences. It's much, much easier for the Trump administration to implement this law now if they have to, if the problems with it are litigated case by case by case by case all around the country, as opposed to in one forum in one place. So it's a significant win for the Trump administration as to that law, even if it's not a direct affirmation of what they've been doing.
Now, as I understand it, the Supreme Court still left the possibility open for a nationwide injunction if perhaps a state or a bunch of states' cases are in front of the courts. Is that right?
Yes, I mean the posture here is it's a common way these cases get into court. It's called a preliminary injunction. In theory, it's just setting the rule for while the case is in court until it finally reaches the merits. But as a practical matter, it's the whole case because they turn on questions of law. So it has a lot of value because that's where a lot of these cases get decided. But what happens if you do have a state? That's different than if you just have one person or one group or something or a whole bunch of states. And so there is some room, both because of who the people were that brought this particular case and of where the court was in the process of evaluating the case relatively early in the process still, that there could be some kind of broader injunction down the line. But the court was pretty clear about where it's coming from. And it says when the Constitution was drafted and the Judiciary Act in the late 18th century created the federal courts, nobody had any idea that there was such a thing as a universal injunction. And so we're just not going to read those laws as allowing that now, even though people make good policy arguments for it. We are an originalist court and we follow the originalist understanding whenever we can. So it's going to be hard to get out from under that originalist reading unless you have a very significant difference in where you are in the case and who's bringing the case.
So before I get back to that as an issue, because I think there are widespread legal ramifications for
Mm.
the ruling going forward, getting back to this particular case on the president's executive order to end birthright citizenship, you spoke a little bit about it before, but really, what comes next? So this basically allows
Mhm.
the president's executive order to take effect while a lower court decides the overall case. Is that what's going on here?
Pretty much. The last page of the order says that there's a delay that they've agreed to for some period of time so they can go back down to the lower court, but that the administration is not enjoined from making plans to implement and carry out its regulation. And so it's going to go back down to the district court. People will make arguments about injunctions, but the administration can begin enforcing it once it runs through that little 1 month waiting period against whoever there may be out there. And so people that want to challenge this law are going to have to develop a couple of alternative strategies. They're out there, they can be done, but there's a reason people have been trying to get these nationwide injunctions. They're a lot simpler, they're a lot cleaner. There's a one case, one shop shopping kind of thing. And the alternative strategies are going to go, they're going to be used, are going to be widespread, hard to manage, and the courts are going to have trouble keeping up with them if a whole bunch of people start bringing challenges individually to this law.
So getting back to what you said, as far as there's a 1 month stay, or how does that work?
We're looking at the end of the opinion. It seemed like the government had agreed to wait for 30 days to begin more serious enforcement action. I wasn't entirely clear what exactly was involved, but there was some sort of agreed waiting period, basically to let the case, move to the next place it's going to be back in the trial court. But it also said right before that that it was the court was voiding any order that kept the administration from planning ahead about how they were going to go forward and enforce and implement this executive order. So during that period of time, the administration is free to make plans and think, okay, we're going to do this, we're going to do that, we're not going to do this. And there's no order that blocks them from doing that now. This court's focused on those people, and the Supreme Court said, go ahead and make plans.
And this doesn't give any indication of how the court would act on the actual merits of the case, as far as, is it really constitutional in which, birthright citizenship or not, right? That's
That's
yet to
true. It
come.
took great pains actually to say we're not going to talk about that. And it said, look, this is an important issue. People feel strongly about it, but it went back to the end of the Biden administration and said, every time the Biden administration did something, it got tied up in court too. This issue of courts having kind of a veto power over what Congress does has just gone a little too far. Now, the next question is going to be, let's say the Supreme Court does hold that it's unconstitutional and some individual challenge to the law. What are they going to do to enforce that ruling? I mean, it becomes precedent at that point, but what does that really mean if you have trouble getting broad injunctions to enforce it? There's going to be some practical consequences of this that I think it's going to take years to think through how it's going to play out.
Well, this does happen on a multitude of cases where, there's a case in Texas, or there's a case in California, or wherever. And all of a sudden there's this
Mm.
one single judge, a district court judge, the lowest level of court judges, has a decision and it impacts the entire country.
No, there's no question this has been a sort of a situation building for a long time. Two examples. The abortion medication litigation is based in Amarillo, Texas, and there's been a lot of dispute in addition to the merits of that case about why is one judge in West Texas making national abortion policy. That is going to be a subject of discussion now in that litigation. Maybe it's different, maybe it's not, because some states have intervened now, but that was a big argument in those cases when they were in front of the Supreme Court last time. And of course, there are the vaccine stuff during the course of the COVID pandemic. Somebody would do something, you'd be in court, and you were in court as much as you were in the FDA at the time. And so that's gotten a little bit simpler in some ways to make policy, but the litigation about it in some ways has gotten even more complicated.
Last question. We're waiting for the Supreme Court to come down with its ruling on a Texas case.
Hmm.
This was about the state law requiring age verification on adult websites.
Yes.
And so, how big of a deal is this case, do you think? Because there are other age verification laws just passed by the state of Texas.
No, for the adult entertainment industry, it's very significant because the program that Texas had, one of their arguments was, we hear you, it's a good idea to try to keep young people away from this, but the way you've done it deters people from ever logging into our system, and it's going to hurt our business, maybe put us out of business. So there's a significant commercial interest in it. In addition to the moral issues about people having access to stuff they probably shouldn't, there's also just kind of a housekeeping aspect of this case. The cases that were being cited in a Supreme Court argument were just kind of old. They were about magazines and newsstands, and they were just sort of dated. And in the modern era where you can click and do this, we just kind of need a refresh on some of the case law. So we don't know what they're going to do yet, but part of what they're going to do, besides resolve an important First Amendment issue, is keep in mind these business issues as well as just the need to every now and then just kind of update the law.
Very interesting indeed. We will keep an eye. David Cole, appellate attorney in Dallas.